Thank you and good afternoon. Just a couple warnings before we get started is that this is not a substitute for legal advice. You should always consult with your own attorney regarding what's best for your particular situation. And since we do have a tremendous amount of material to cover in just 25 minutes, I will hold off on answering questions until the last 5 minutes of this presentation. What we'll be covering today are first off, the advanced directives overview, addressing the legal tools that outline future medical decisions, defining the uses of a living will and a healthcare proxy, third, communication with your family, and then finally, information regarding your employee benefits through the EAP will be explained. So all of us have a constitutional right to refuse medical treatment. However, how do we make our wishes known if we later become incapacitated and are unable to express ourselves as to what our medical wishes are? So to do that, you must have written legal instructions regarding your healthcare wishes and provisions when you're incapacitated. This will help your loved ones and medical personnel make important decisions during a crisis. This is all dependent on state law. The terminology is different in each particular state. Healthcare proxies are known as medical powers of attorney in other states. In New York, we have healthcare proxies and living wills. Sometimes they're separate documents, other times they are combined. One of the myths about estate planning is that people think that they're too young to need a healthcare proxy or a living will. Unexpected health issues can come at any age. Two of the most famous advanced directives cases were women in their 20s. Karen Quinlivan, from a combination of alcohol and drugs, was in a coma for 10 years. She was kept alive merely by a tube feeding. Terry Schiavo, the famous case, she was kept alive for 11 years by a feeding tube because they could not discontinue her life support. And I'm sure many of you may have seen Terry Schiavo on TV. Even the governor of Florida intervened in attempting to keep her alive while her ex-husband and her parents fought over her medical care decisions. And I'm sure she would not want to be remembered the way she was on TV, hooked up to all sorts of medical devices. So what happens when you have no healthcare directives or have made no plans and you become incapacitated or incompetent? Well, New York in 2010 enacted the New York Health Decisions Act. And this is even more of a reason to have a healthcare proxy and a living will. Because if you do not have a healthcare proxy and living will, then the New York Healthcare Decisions Act spells out who can make healthcare decisions for you. In this order: first, if a guardian was appointed for you as an incapacitated person. Secondly, your spouse or domestic partner. Third, your adult children are next in line. If none of them are available, your parents can make healthcare decisions for you. Next are brothers and sisters. And finally, close friends can make healthcare decisions for you. So children, for instance, you may have children that you haven't talked to in 10 or 15 years who have no idea what your healthcare decisions wishes are, would be able to make healthcare decisions for you. So to avoid that from happening, you need to designate a healthcare proxy and an alternate healthcare proxy who can make decisions for you based on their conversations with you. An advanced directive is only used if you are in danger of dying and need certain emergency or special measures to keep you alive. An advanced directive allows you to make your wishes about medical treatment known. So these advanced directives we're talking about, first, the healthcare proxy and living will, are only used in a nursing home or a hospital setting. We'll talk more later on about other advanced directives that are in addition to these. So there are two main documents known as advanced directives. There's a living will, and this specifically spells out medical treatments you would and would not want to be used to keep you alive. For instance, you can indicate whether or not you want CPR or mechanical respiration. In addition to the living will, there's a healthcare proxy. It's a document with which you name someone that you trust to act as your agent if you aren't able to speak for yourself. It's extremely important to keep it updated after any life events, which we'll talk later on as to when your healthcare proxy may be revoked. So we do a combined healthcare proxy and living will, or it could be separate documents. You need both of those. A healthcare proxy alone does not give your agent full authority to do certain things as discontinuing tube feeding or artificial hydration. For that, you need to have a living will to spell those types of things out. So for instance, your living will would state whether or not you want to be kept alive in various situations, such as if you're in a coma, terminal illness, or even non-terminal illness. For instance, later stages of Alzheimer's where you lose your ability to function. Also, the living will spell out whether or not you want to be provided or withheld tube feeding and artificial hydration. Your healthcare agent cannot make those types of decisions for you unless you've spelled it out in your living will. So the living will is a written document that helps you tell doctors how you want to be treated if you are dying or permanently unconscious and cannot make decisions about emergency treatment. It'll be used to determine whether to extend your life and under what conditions and situations. We have some people that want all measures taken. They state in their living will, they want all measures taken to keep them alive, including CPR and artificial hydration and tube feeding. But most people, probably 98% of our clients, do not want extraordinary measures taken if they become incapacitated and cannot make decisions for themselves. So your healthcare proxy and living will go into effect when it's determined that you are incapacitated and unable to make medical decisions for yourself. A living will is different than a will used to pass property and assets after death. A living will is different than a healthcare proxy. And it's different from a last will. Living will just relates to medical decisions, unlike your will, which takes effect upon your death to pass property. Also, a power of attorney is a separate document, which covers financial decisions on your behalf. So if you execute a power of attorney, that can give your agent authority over all your financial matters, but not your medical decisions. The only thing medically related by a power of attorney would be authorizing your agent to contact your medical providers in order to pay your medical bills. So the various healthcare situations covered by a living will are, what if you were no longer to breathe on your own? Would you want medical treatment discontinued? What if you're unable to feed yourself? How do you feel about feeding tubes? Most people don't want feeding tubes if that's the only thing that's keeping them alive. What types of pain management drugs or procedures would you be comfortable with? Do you want DNR, do not resuscitate, or DNI, do not incubate? So your healthcare agent can request that your doctor sign a do not resuscitate. A do not resuscitate and do not incubate, those are orders signed by a doctor at your request or at the request of your healthcare agent. How do you feel about donating your body organs after death? The healthcare proxy living wills that we prepare contain provisions for donating organs. there's various options there. You can donate any organs, or you can specify on our living wills you only want to donate specific organs, and you can specify for what purposes your organs will be used for transplant, research, education. Living will goes into effect when you're unable to communicate, but you're still alive. Such as if you are confused or in a coma because of a head injury, doctors would want to look at your living will for direction. At the moment you can communicate on your own, your living will becomes unneeded and has no authority. You'll want to make sure your living will is prepared according to your state's specific guidelines. So New York has specific guidelines for living wills. Living wills came about as a result of a New York Court of Appeals case. Healthcare law came about through New York legislation. Each state is different. So if you do move out of state, check with the attorney in that particular state if your healthcare proxy is adequate. When does a living will terminate? Upon your death, it automatically terminates. You can revoke it. You can execute a new living will or healthcare directive, and if you get divorced or legally separated, your living will and healthcare proxy will terminate. So these are the types of things that you should be updating if you're divorced. Healthcare proxy. Healthcare proxies came about as a result of specific New York legislation. You can give your healthcare agent as much or as little authority as you want. The hospitals, doctors, and other healthcare providers must follow your agent's decisions as if they were your own. So your healthcare agent can speak for you as if you are speaking. Both the living will and the healthcare proxy require 2 witnesses. And we also, it's not required, but we also notarize the healthcare proxies and living wills because other states do require notarization, such as Florida. So that would make it still valid possibly in other states if it's notarized. So it's not required, but we do notarize the signatures of our clients on the living will healthcare proxy. You can appoint 1 agent and 1 alternate agent. But you don't give up your rights. As long as you're still able to make healthcare care decisions on your own, as long as you have the capacity to do that, your healthcare agent does not have any authority. And then once you do become incapacitated, once a doctor does ascertain that you are incapacitated, then the agent has the authority. As I said, the healthcare proxies and living wills are only valid in hospital and nursing home settings. So if the EMTs come to your house and you're in cardiac arrest or some other medical event, they don't have to honor your healthcare proxy or your living will. The only thing they would have to honor would be a medical order for life-sustaining treatment or a do not resuscitate order. These are documents that are signed by a doctor in consultation with you. Medical orders for life-sustaining treatment are also known as physician's orders for life-sustaining treatment. These are for patients who want to avoid or receive life-sustaining treatment, and patients who are in long-term care facility or require long-term care services or may die within the next year. So if someone's at home under hospice care, they need to have a MOLST so that if they're under hospice care, they do not want to be revived. They would have to have a MOLST sign so that if the EMTs do come to their home, that they can treatment can be refused and they can be allowed to die. DNRs, seems to be misunderstandings regarding that. Those are written orders by the doctor that instructs medical professionals not to perform CPR or restart your heart or lungs when your heartbeat or breathing stop. So you would most likely, if you wish, have a DNR sign for a specific medical procedure or surgery that you're undergoing. When does your healthcare proxy terminate? It terminates upon your death. That would be automatically terminated upon your death. If the purpose is accomplished, if you just have one specific purpose stated in your healthcare proxy, if you destroy your healthcare proxy or it has an expiration date on it, very few do, but you could put an expiration date on your healthcare proxy. For instance, if you were just going in for surgery and you only wanted the healthcare proxy for a specific surgical procedure. You can revoke your agent's authority either orally or in writing. You can revoke your healthcare proxy that way. If your agent dies, becomes incapacitated, or resigns, if your healthcare proxy dies, becomes incapacitated, or resigns, then the healthcare proxy is terminated. If your spouse was your agent and there's a divorce or legal separation, then the healthcare proxy will terminate. So what's important about these documents? Many people have healthcare proxies and living wills, but a couple shortcomings are either they don't know where they are. It doesn't do you any good unless you know where it is, where your healthcare proxy and living will are, or you haven't communicated your wishes. You haven't communicated your wishes to your healthcare agent or your healthcare proxy. Your healthcare proxy has a lot of leeway in carrying out your wishes. So just like you would want to get second or third opinions from doctors before discontinuing medical treatment, you need to let your healthcare agent know what your wishes are. So as soon as you complete your healthcare proxy and living will, talk about your decisions with your agent, your loved ones, and your doctor. Give your doctor a copy of your healthcare proxy. If you go to the hospital, make sure the hospital has your healthcare proxy and living will. Schedule a time to talk this over with your family and friends. Talk about your values and your beliefs. People have certain moral and religious beliefs about medical treatment. You should let your agent know what those are and what you consider to be a good quality of life if you do sustain any medical issues. Approach the conversation wanting to share your wishes before you ask someone else to share their own wishes. And you should be prepared to have numerous conversations so that your family and your agents know what your true wishes are. Your family cannot overrule your living will. They cannot take away your authority to make your own treatment or care plans. That's why I say it's very important that you do spell these out in your living will, what your specific desires are as far as your healthcare proxy and your living will. So again, if you need end of life advanced directives, then in addition to your healthcare proxy and your living will, you will need a medical order for life-sustaining treatment and or physician's orders for life-sustaining treatment, and also request a do not resuscitate order. So the living wills and healthcare proxies can be very basic documents, but can really go a long way in expressing your wishes regarding healthcare. As I said, we do a combined healthcare proxy living will. It's a 2-page document in which you would name a person to be your healthcare proxy, and then specify whether or not you want to be kept alive by machines in a situation which could be either terminal illness, in a coma, a non-terminal illness, and whether or not you want tube feeding and artificial hydration, as well as donating organs. You can provide that, and there's various ways of donating organs, but one of the good ways to do that is, in addition to your driver's license, is on your healthcare proxy and living will. And as I said, the healthcare proxy and living will are both signed before two witnesses. And they do not need to be notarized, but we do recommend that they are notarized. I can take questions now at this time.